welcome to everyone, and thank you for having me back to a Lunch and Learn. This is my second visit to you all here. Pete Lilly is visiting with us as well, and he is running a camera to tape this so that we have it memorialized. And I'd ask if you have questions to try to save those in-depth ones or hypothetical ones till the end and when we're not filming. Having said that, oftentimes people say that lawyers are kind of boring to listen to, so I thought I'd start off with something interesting. And a few lawyers sent me a few IP lawyer jokes that I decided were completely inappropriate for an educational institution's lunch hour talk. But I thought I'd start out with having you look at the exhibit that I sent you and asking you and pointing out to you why the objective of learning about IP law is so important wherever we are in life. This particular item is a patent, the one and only patent that any of our presidents of the United States have ever filed for in the United States. And I'd just like to ask anybody if they know which president filed for that patent or what that is. I think that someone might know in the audience where this patent is from. And which president is this from, Kathy?
I think it's Abraham Lincoln.
She knows because she was watching me photocopy it when we got started. It is, and the Smithsonian Institute, as you can see from the hyperlink I've posted, has this replica as of 1908, but he developed it much before that. Patents and all forms of intellectual property, there are 5 that we're going to cover today, are really, really important to our everyday life. And so while you're sitting here and you're thinking to yourself, this is kind of a heady topic, what I would tell you is that the purpose for us having this in an educational environment at MCC and in a business law course, I teach Business 241, and this is, if you take it in the 16-week version, it's week 8. If you take it in the 8-week version, it's week 4, is not only for our corporate clients that come in to MCC to take classes through the fast track, who might need to know how, if I have an idea at work, what do I do with it? Does it belong to my company? Does it belong to my college? Does it belong to my employer? But also, I've found in my 10 years here at MCC 2 very astounding stories of students who have taken the materials that I'm giving you today and in their own solo proprietary way have become entrepreneurs. And one student here and her grandmother took their spaghetti sauce recipe, and their spaghetti sauce is now being sold at Trader Joe's, and have launched a business that way. And I have another student who is in the movie industry who also does apps, and he sells them to phone companies and also to Google and Microsoft and folks with his production technology. So knowing whatever your idea is about how you're going to make money in life, whether it's a part-time fanciful thing like your grandmother's spaghetti recipe or it's something for your company, it's really important that you understand that what intellectual property is literally what the words suggest. This isn't real property like a house. It isn't chattel like a car. It's the ideas in your head. And they come out in 5 ways that we're going to talk about. But my first and most important thing I want you to understand, and the first assignment I give any of my students in terms of intellectual property is knowing that you need to preserve the name. And so I give them a challenge when they start my course of checking their own name. And every semester, my students are astounded to find, as I was, that their name was already taken in the state of Illinois. And so their assignment is and yours too. This is not a classroom that has computers on, but at this point, we would stop the lecture and I would have Kathy Hayhurst, Peter Lilly, Stephanie, go check and see if someone was using your name already. Because there are 4 Mary C. Ambroses in Illinois, and that was what I found. So my students who say to me, why do you have this crazy last name with a hyphen on the end of it for your corporation, is because Mary C. Ambrose already belonged to 4 people before I got here, and I looked it up as my domain name. So I've added my married last name, and the PC designation is for a professional corporation. So what is a domain name, and people said to me, what's the laws of the cybernet and what's the laws of the internet? Cybernet is not the term that's really the term of art anymore. People refer to it more as the internet, and I always tell my students when they get to the question on the test, do not write back to me that what is cybernet. It's the it's the laws of the cyber. You have to explain what it is, and you have to explain what the internet is. But if you think about ideas that we have floating around in space and ideas that we have floating around in our heads, and now that this is our form of communication with each other, that gives you an idea of the very intricate world we're headed into. But I'd suggest to all of us first that we check our own names and see, is my name available? I'm sure Kathy Hayhurst thinks that her name is unique, and Julie Freelove has joined us, Peter Lilly. What I make the students do is I want you to check on the computer and see if your name is being used anywhere in the world. And if you find it being used, your assignment is also to bring to us, who is that famous golfer? Who's that famous actress that's using your name? Who's that famous producer? And it really sends us off into an unusual study, but you need to know if you can use your name. And if you can't use your basic name, my suggestion is you stick your middle initial in, you stick a hyphen in, you stick your maiden name back in, and that you play with it until you can use your name. The best sources to check and see if your name is or is not available, and the three that I typically direct them to, is not only register.com, but godaddy.com, and most importantly, for those of us who are taking this class in Illinois, is the Illinois Secretary of State's website, and that's on here as well, under B. You can look on other sites, and there are other, I think I noted there's a few other places you can look. You can look on networksolutions.com. Some students will write back and check whosits.net, domains at google.com, the Illinois Public Domain Name website. But if you are going to sell anything in Illinois and the Secretary of State has someone else selling something using your name, you're going to get a letter from them fast. So you want to very quickly make sure you always check the Illinois Secretary of State site. There was a business on Northwest Highway that was named Gee Whiz, and it was in Barrington, and there was a business further up the road here in McHenry County named Gee Whiz. And they obviously didn't do this exercise that I'm telling you to start with first, and one of them had to change their name to G.Whiz, and the other one got to use GEE Whiz. But already having put your business's signs on your doors, your business cards, and all your merchandise being labeled the wrong thing can be an expensive proposition if you don't start with a domain name search first. And
Can I ask a quick question?
Sure.
If you have a really common name,
and I have a lot of students that have common names.
like Bill Smith,
Then-
should you automatically assume you're going to have to be creative?
Yes, so besides changing your name around as I have with my name, you can also play around with what's on the end. And so people say to me, well, Mary, should I be a .com? Should I be a .org? Should I be a .biz? And just to give you some savvy so that you sound like you know what you're talking about, and if you decide to go register yourself today, 51% of the people that are on the internet typically pick .com. .org typically has suggested that you're an organization of some sort, like a not-for-profit or a school, and that's kind of the way it was sort of formulated. There's .info and .ibiz and .biz. Those are kind of looked at snobbily as if they are the spam sites or the advertising sites. So maybe you want to advertise whatever it is you're selling, so maybe you want one of those, but that's sort of the hierarchy of the extensions at the end. And and my website is .com, but it didn't have to be. It could have been .org. And what, for example, is MCC's?
.edu.
.edu, and that's another designation that tells people what you are necessarily. But and somebody had to take the time to go register. And if you've ever looked out there, there are other McHenry colleges. It's about registration of a name and saying to everybody in the world, I have this name. It's not enough to register the name here in Illinois. You're going to have to register it nationally and internationally, and we'll talk about that a little bit more. But again, if you have something special that is special to your family, in my family it's more peanut butter ball recipes or things like that, and you're thinking about it, copywriting that or patenting it or having a trademark associated with something that you have at home or something that you've thought of along the way. I've had a student copyright a song in my class, like I said, the recipe, the Italian recipe that's at Trader Joe's from one of those students. So, but you gotta save your name first. That's your very first step. You don't have to go to a lawyer to execute that step. You can just go to those websites. So like I said, register it now and preserve it. You'll get reminders, are you still using this name? You also need to check on it, and you don't have to check on it and behave like a cyber squatter, but there are people out there that buy up names. And when something's invented, they go out and buy up those names very quickly, and you will find that, it's amazing. If a word is entered the Oxford Dictionary, it's probably also had its domain name purchased up already. My students will say to me, do you really intend me in class to buy my name? And I say, no, I want you to go look, and I want you to see how little or how expensive the proposition is of registering your name. And like I said, make sure you check the Secretary of State. The second step that I give my young entrepreneurs or my people in the workplace is this. And Kathy had a leg up on all of you because she was asking me questions as we walked over here. You work at a place. You have an idea. Does that idea belong to you, or does it belong to your employer? And I'm sure all of you who are here in an academic institution are going to say, well, I have academic freedom, but could it be my idea, or could it be MCC's idea? And for those of us who don't teach in, I would think in the culinary department here at MCC, or in the science departments, if in engineering or any of our mechanical classes, they've set out some pretty clear guidelines that if you are developing a prototype or you're developing a recipe, they've told you this is either going to belong to us or this is not going to belong to us, it's going to belong to you. And they've set out those guidelines. But if you're not in those departments and you're in the business department or in the arts department, and you're wondering, how do I know if what I just thought of belongs to me? Where you would look is either in your union agreement, in the policies and procedures that are posted on the MCC website, because believe you me, institutions want this spelled out as much as big companies like Snap-on and Medline want it spelled out, as the state wants it spelled out. You just don't want to be in a situation that now we're moving beyond just your name, but your product is going to be stolen by somebody else who says, but I had that name first, or that I had that idea first. I can remember when my husband and I were both working at Motorola, and this was a number of years ago, my suggestion in writing, and that if you have an idea and you have it in writing, you want to put it in writing, and you want to put a date on the top of when you send it to somebody, was that they add a little hook on the cell phones, and that hook would provide me a place for my car key, one car key, and also a tube of lipstick. And then I would have a mirror inside, and that would be all I needed, and I wouldn't need a purse. Well, we're evolving towards that, but Motorola at the time responded and said, you know what, we're afraid about the tube on the lipstick and a key, getting in the way of the mechanical performances of our phones, and so they didn't want to run with the idea. But what I have in my file is if they ever come out with anything that looks anything like what I suggested to them, I have taken steps to make sure that they understand that was my idea. And the purpose of this is also to spark your creativity, because all of you know that you solve problems in various and different ways at home, and you may just want to take that idea, but the first thing you need to do is make sure you have your name registered somewhere. Why? Because if you have this idea and you want to have it you want to own it, you want to have it owned in that name that I made sure we registered in the first part of this presentation. What's the other thing you want to do? If you decide to go talk to someone, like you say, I think I'm going to go ask Pete Lilly or Pat Staskell if they've ever seen anybody doing this kind of technology on the campus anywhere. I was watching some technology this morning that the Marines have out on San Diego with drones, and they're doing all sorts of amazing things that they're shooting off of drones. And you want to talk to somebody about that crazy platform idea, like you just saw that on TV and you thought, well, I want to not put lipstick on the drone, but put like a gun off of the drone, or I want to put a laser beam off the drone. Before you talk even to your coworkers, you guys, I would recommend that you download yourself what I've listed here as a non-disclosure agreement or a sample NDA. That means if I sit down and I want to strategize with Pete about could I do this idea, putting lipstick on my drone, or putting some amazing peanut butter ball recipe together with the culinary department, and I want to go sit down with the culinary department and show him my peanut butter ball recipe and see if he thinks the way I do this is so different from the Ohio Buckeyes or the Lake Forest peanut butter ball recipe that's called the chocolate ball or the white chocolate ball. And I want to go talk to him. You want to hand him an NDA. And the reason why you do is you want to assert to him or her, whoever you're meeting with, even a friend or a colleague at work, this is my idea. I want to talk to you about it. But you're signing a non-disclosure agreement that means you can neither use this idea, you can't tell anybody else about it, and if you're going to go grab yourself an NDA, I would suggest that you grab one that is mutual or unilateral, but favoring yourself, so that that person that you're talking to can't tell anybody. Maybe you even include your spouses. I don't know. But you want these people to make sure that whatever ideas that you're sharing with them, they understand it is yours. You want to err always on the side of using it. So I think many of you are looking at me like, well, I wouldn't walk around with a piece of paper that said this on it. I mean, or they're very simple forms. They run from 1 to 3 pages. They can be downloaded off the internet. And it's important if you intend to be an entrepreneur and or in terms of academia, if you want to develop an idea, if you want to develop a way to get cheaper prices for textbooks, or you want to develop an idea to improve technology in the classroom, you want to have your little sample NDA with you, and you want to have it so that anybody else you talk to about it knows that you are the inventor of this. It doesn't always work out well, and I will say that I had an idea that I found my husband and I together pioneered some diaper cream, and we called it Bubba Bubba Butt Cheek Cream. We started out by reserving the name. We were convinced that we knew how to cure diaper rash with our first child. And then we filed for the patent, and you go through this whole process. And what you may find out is that people have already thought of your wonderful, brilliant idea in the form of the company Desitin or something like that. But what you've done is you started, and that's how we did it. We also had an idea I had an idea that when I was coming to the front door and carrying the car seat and the backpack and the briefcase and the lunch boxes, that it would be really nice to have a button that unlocked the handle on our front door. And so I started with a name, went and investigated further, and sure enough, there was a company who was holding the patent, just like Abraham Lincoln's patent, and they have not developed it into any idea, but they registered my idea already. But again, you still should start with your name, still should start with your product name, and then you move forward. I don't know if I had you, I'll hold up one of these. This is our president, Abraham Lincoln. He's the only president to have a patent, and this, Kathy Hayhurst, has the inside track on it. It is the patent that he came up with. You know, he's from Illinois, for
A flotation device to raise barges off of sandbar.
he wanted to get the barge off a sandbar as they would get stuck going down the Mississippi River. But he took the time, and the Smithsonian has that, if you want to see it, in 1908. I'm going to give everyone a little treat with one of my demonstration products, because I always use this dessert item in class to see how you guys are all doing on what you already know about intellectual property and the 5 kinds we're going to talk about. So I'm going to pass out. Everybody feel free to eat these after you study them. These are Oreo cookies. And there are 5 kinds of IP with these Oreo cookies. And that's my introduction to the section we're covering now, which is what are the 5 kinds of IP. The box that you see the Oreo cookies in would be what is the 5th kind, which is trade dress. This is the dressing, and there's dressing around products typically. And you can see from this particular box by Nabisco that they are fond of the royal blue color. They think the white lettering shows up the best, and they have the cookie gracefully launching itself into some milk in the corner, and this is their trade dress. That means they will register the way this looks, and in my course we cover a lawsuit with a biscuit company in India that they've been up against because the company literally had the same trade dress. Anybody want to, hold it, I'll give you one more, I need a cookie. Has everybody got one?
Yep, sorry.
That's okay. Anybody see any markings on this cookie that might tell them another kind of IP?
I think the trademark.
There's a tiny TM in the chocolate. You see it? And that's trademark. And they have trademarked the O in Oreo. They have a special O that you are not supposed to use because it's their O. And they've also trademarked the name Oreo itself. Any other suggestions about potential IP from this cookie? Corey, you had my 241, you remember? Anything about the white cream? It had it has special.
The recipe?
It had yes, it has a special recipe, and they have that, and it is patented. So that's and just like McDonald's has their secret Big Mac sauce, or Kentucky Fried Chicken has their chicken batter recipe, those are patented. So that's a patent. The trademark is the design. There's also some copyright with Oreo and the drawing that they have surrounding it. So there on that very cookie is 5 kinds of IP. So say you thought of a cookie, or say you thought of your grandma's spaghetti sauce recipe, you may need not only to look at the jar for trade dress, but also the recipe, and you may want to either copyright and or patent the recipe depending on what you put in there, and you may have a trademark on the side, and you may have copyright. And having told you all those attributes to just one single product, you're saying to yourself, well, I'm not going into business. What's this going to cost me? And also the trade secrets is another fifth kind of intellectual property. The trade secrets are not registered. Patents, copyright, and trademark are registered. So you can pay as a small entrepreneur, depending on your product, about $2,000 to $3,000 to just go initially try to file each of those. So if you're asking me in terms of cost, that gives you an idea. Your trade secret is a whole nother story, how we deal with that. And your trade dress, it depends on if there's something that you want to say is really unique to your company. Another item I have up here is the McDonald's famous yellow M. Now, you've probably all seen the Motorola white M, right? So M is available, but you have to make your M special enough by color. This is a very soft shape on the M. On the Motorola M, it kind of has angles, and then it almost looks like it's coming to a peak at the top. So those are things that you have to get graphic folks helping you with, or you have to design something if you're going to use an alphabet letter that is unique to your company before you go to try to register it. But that'll give you some idea where we're headed. You know what a trademark is because you all spotted one. This is a mark that identifies their product. The Lanham Act is the first resource we had for trademarks, and it gives you an exclusive right to register it and prevent other companies from using it. And the Patent and Trademark Office, you can see in DC, it does both patents and trademarks. The Copyright Office is separate. I read that there were 150,000 patents filed this year, and we have about 16 million that they have responsibility for. If you're wondering about the whole process. If you want to register a patent, a copyright, or a trademark, you can do it online yourself. People say, do I need an attorney? No, you almost need more help just sorting out what makes your M, your cookie, look different. And that isn't necessarily going to come from an attorney. The legal materials are pretty relatively simple in and of itself. But it's the making sure that your similarities between your cookie, your M, your peanut butter ball don't look like anybody else's. And you oftentimes will probably seek out marketing people or design or graphic people who can make you look slightly not similar, so to speak. A patent is something where you're trying to promote the progress of science and secure for limited times to an inventor the exclusive right to that discovery. And this is a constitutional right that was buried in Article 1, Section 8. And again, a patent is also something that is preserved by the Patent and Trademark Office. In a little more in-depth time, because I see we're halfway through, we would cover the 3 kinds of patents that there are. Copyright, which is an awful lot of fun, and you can see I liberally used it on the back of my outline today about my own teaching materials, and I'm sure you folks use it around here. Copyright is signified at the end of something with the C, or you can write the word copyright as I have, and you want to write the year. Because you may have successive drafts of something and you want to date it for the next year. On a Mac, I use a Mac, it's option G, but you can also find the symbol for a copyright, which I have poorly drawn, on your computer. So you can put that at the end of memos or ideas that you're sending around. Copyrights are interesting in that they have to do with art. So when I mentioned that I had a student that wrote a song, or you have I had a poem I wrote in 4th grade, if I wanted to copyright it, Spring is here, the grass is green, the little flowers can be seen. That was my poem. If you wanted to copyright that, you'd have to start with reserving your name, having a title for the poem, start looking to see if anyone else had it. And then there's something very interesting about copyrights that is not applicable to the other four kinds of IP we're talking about today. And that is, they have a limited duration. Does anybody know what the duration of a copyright is? Stephanie, how many?
25 years?
It's like 50 or 75 years depending, after the death of the person it belongs to.
It doesn't, but if that person has an estate, doesn't it still?
Sometimes, and it also depends if they put it in the public domain. If you already offered it up, and like say I didn't put a copyright on my speech today, then Peter Lilly could steal it and run lunches without me. But I've put it in the public domain and I've indicated it belongs to me. Let me give you an example of how I see this happening in everyday life. I had 2 children that participated in the Barrington speech tournament every year in 5th grade. And our son, who is 4 or 5 years older than his sister, participated, and he used Paul Revere's Ride, he used the Declaration of Independence, and he used Edgar Allan Poe's The Raven for his 3 selections. And maybe many of you have heard of those. When our daughter came time to participate, Barrington had adapted a new policy. You could only use speeches from an author named Silverstein and Beverly Cleary. They had specifically checked out 3 authors and said, there will be no Declaration of Independence, there will be no Paul Revere's Ride, and there will be no Edgar Allan Poe. And as a young parent who knew that I wanted my kids to know the classics, I don't really have a problem with their very narrow view, which is they had gone to those authors, Sheldon or Silverstein, and they had made sure that Barrington had permission to reprint the texts of their books or poems for speech purposes, and that the children could then use them without any liability for the district. But and you can say it's a technical legal argument, but it is an accurate one, is the Declaration of Independence is out in the public domain, and anyone who's in school probably learned to recite some part of We the People. And so it is not something that they need to worry about there being any copyright objections to it. And Paul Revere's Ride, and also any of Edgar Allan Poe's material, those authors who may or may not have had copyrights on those wonderful classics that we own are long since gone, and those poems are also considered out in the public domain. So I didn't see any reason why they needed to be so narrow in their focus. And I found it also, as an aside, a bit ironic when I had a child participating in theater, and you can hear occasionally that they've taken the time for the big spring productions to buy $3,000 worth of musical rights to My Fair Lady, etc. Back to this copyright issue. But in the day-to-day classroom work, I'd say I've seen an awful lot of people use other people's work here, very liberally without checking out copyright. Whether it's a problem that some other teacher's given you. And I've learned as a faculty member to be very cautious about taking work from other people, because I've seen people tell you that they wrote it and it doesn't belong to them. And embarrassingly, I found out on one occasion here from one of my students that we were using a problem that came from the University of Oklahoma, and I don't think we asked them for it. So, so I'd say to all of us that are in an academic sense here, you're here for an academic purpose to talk about copyrights and stuff, that you take the time to stop and look up a copyright and make sure you either know that it's already been in the public domain, it's not somebody's, if someone's still alive and it's not 50 years since they wrote it, you really need to make sure you know what you're doing if you're going to use somebody else's work. After having finished a little bit of our conversation on copyright, I'd like to talk about trade secrets. And I mentioned to you that you don't have to go register a trade secret in a formal federal office and pay $2,000 or $3,000 to register it. But what you will find, and when you go to work some places, that your employer will hand you a document and it will be attached to your employment agreement saying you agree that you're going to keep any trade secrets confidential. And the biggest disadvantage the employee has when receiving something like, I'm going to keep the trade secrets confidential, is very frequently it's handed out when you first start on your first day of work, and you raise your hand and you go, I don't know what secrets you have. What am I keeping confidential? And most employers don't do a very good job of going around labeling things trade secrets, or coming back to you, and each time they give you a trade secret, or today I'm going to tell you how we make the diaper cream, or today I'm going to teach you how we, make the cookies. Do they stop and say, and this is the secret that you're not supposed to tell? On the other hand, I've seen 30-page trade secrets agreements that still don't have a product list attached to them. So that's typically where the rights about trade secrets are embedded. And I don't know, I've never been given a trade secret agreement here or told there was anything secretive here at MCC, except we weren't supposed to tell about the mascot till he came out or whatever. But I mean, and I think that's because we're in an environment where there's a lot more freedoms, et cetera. But you need to know what the secret is that you're being asked to keep. Also, trade dress. People don't necessarily, take the time to remember that you have to, bless you, you have to protect this product too. And and then when I get to some of the other products I brought with me, people would sell bags, the shoes and boxes that shoes go in, and they forget, oh yeah, if I've got that name, on the front of the box, I better make sure that I also send that photo in and also protect that when I am registering whatever you're doing with your product. Question under 4A here is, where do you register them? And as I indicated, you would register the first 3 at the federal offices we've talked about online, and the other 2 you do contractually with your employees. And there are national or international rights. And what I mean by that is, you can imagine how much McDonald's spends a year in monies to protect their M in Russia, in Italy, and any place they sell McDonald's foods. We have the Berne Agreement, and we have an amendment recently to the Berne Agreement. Not every country in America, or in the world, has signed on with America so that the copyrights laws apply in those countries. Sometimes you have to investigate and find out, well, in this country, does Australia participate in that agreement? I'm selling my stuff in Australia, I'm selling my stuff in Europe. Are they part of those international agreements, or am I going to have to pay their agencies in each country if I'm going to sell my French fries there? So that becomes expensive if you do have a product. I'm not sure that my student who's selling her spaghetti sauce is selling it anywhere but Trader Joe's, and I don't even know if Trader Joe's is out of the country, but those are threshold things that you need to figure out before you start selling anything that you make or that you have. Be very careful of generic names. And I know that my students who are here in the room remember we discussed the Harley Davidson case and the Victoria's Secret case. There was a gentleman that was selling lingerie, calling it Victor's Secret. And that's a very similar name to Victoria's Secret. And had he actually gone through the steps of trying to register that name before he started selling things in Kentucky, he would have found out that the patent, trademark, copyright people would have told him, you can't have that name, even if your name's Victor, because it's too similar to that name. There was a gentleman who was running a Harley Davidson repair shop, and he was trying to use in various forms Harley Davidson's name, but not necessarily to indicate he was selling Harley Davidson products or repairing it. He was using the name, and they sued him, and he was also using the word hog, which has a designation for the size of a particular Harley Davidson bike. And the split for him. They said he couldn't use Harley Davidson for the name because that's, everyone knows, is that motorcycle company. But hog, they hadn't taken the time to preserve the name hog, and hog, he could use hogs generally more as a generic name and not as a specific name. So depending on whether your name is famous and it's been used as a golfer or an inventor, or you may find that your name, you might have to go to something more generic with your name that you've come up with as well. Again, watch, as I mentioned in item E, use the use of C, and I'll actually put registered trademark, the symbol as I pulled it up off the computer on your handout, and the color and shapes and changes with the letter. At this point in time, I'd like to show you a few more products, and I'm going to just hold this one up by an exhibit. I have a brother-in-law that decided he would like to make beer and pop bottle openers and put superheroes or other things on his wonderful $4 or $5 product. He also decided he wanted to make hacky sacks too. And so he came to me and he said, I'm just a solo entrepreneur. I travel the world and I get these colorful fabrics. I'm going to make these hacky sacks out in Seattle. And do you see any issues? And of course, I told him right away, you better reserve your name. You better register what you're doing. He said, some people put sand in them, some people put pellets in them. I'm going to be unique. And we encouraged him to make sure that whatever technology he came up with for this product and also for his little hacky sack bags, that he took the time to pay the money to protect those things. And lucky for him, when Nike came knocking on his door, suing him for the hacky sacks, and he was also sued for these little pop bottle top openers, that he'd actually paid the time and put the time in it and paid the money to protect himself. Because if you're a small little entrepreneur and you're out there on your own and big Nike comes after you, they have a fleet of lawyers and they have lots of money and they have lots of money and time to go register internationally, and it can oftentimes bankrupt the small entrepreneur. Similarly, I'm going to pass around and everyone can take a look at these shoes. And again, I'm going to test you a little bit. And I think there's 6 of you. There's one, everybody can have a shoe. But you can't have two. There you go. And I'm going to see if you've learned much from my lecture on can you spot the 6 kinds of IP on this shoe? Or 5 kinds of IP.
There's a logo in there.
Okay, and the logo is trademarked. And it says Diana E. Kelly, if you can read it. And this is my cousin. Anybody see anything with the brooch that looks patentable? Yeah, there's a very special E that's copyrighted. It's a unique E. The E looks like, we had her change her name, like it's more like that kind of an E, not like this kind of E, which is already taken. Very good, Julie. Anybody see the unusual part about the clasp underneath with the brooch? That's the patent item, because you may have had shoes that have stuff on them where if you put your foot in it, the next thing you know, when you take your foot out of the shoe, you've got a red spot, you've got a mark. There's actually a special patent with fabric under there, so you won't irritate the top of your foot. If you would like to try to put the shoe on anyone, you will see it's a very comfortable shoe. So the copyright is. Yeah, I have the flat on, so Pete can get me in the video. So we have a patent with the clip. We have copyright with the E, and the name is registered as her trademark. And then we have trade dress. They came in bags and boxes. That's the dress. And the trade secret, that as well as the patent, is the clip in the front. So when she told her mom and dad that she wanted to make shoes, it became a very expensive proposition, because her 2 lawyer cousins were all over her that making shoes and putting them out there in the stream of commerce while she was finishing up an MBA and she was coming off of being Miss Florida runner-up twice, and she was trying to think of something. These shoes, as you know, don't look very practical for teaching here at MCC, so they're more like what I think that the beauty pageant type of contestant or socialite might wear around, because I don't. And because of their height and their beauty and their expensive nature, et cetera. But we said, you better go register all this stuff, and you better pay the money up front to make sure you register it, and internationally. And sure enough, much to our surprise, one of the first letters that Diana received was a letter from the Grace Kelly Foundation in Monaco, who'd hired a major law firm in Paris, and they'd hired a big law firm, I won't say their name, in DC, to write threatening letters to Diana that she's got Kelly in this name. And our defense was, her name is Diana E. Kelly, and she did register this. And we are 6 cousins removed from this famous person in Monaco, but Diana had taken the steps to preserve the name. I don't know if you go into DSW today, you will see Kelly and Katie shoes. I don't know if they've had a similar issue, but the Grace Kelly Foundation anytime anyone wishes to start using the Kelly name, starts writing letters to you, and they're warning you, please don't use, and they did write an agreement letter with my cousin not to make purses like the Grace Kelly bag. There's a famous bag that she used and carried around in the 50s to hide the fact she was pregnant, and I believe the bag is made by Hermes and it's thousands of dollars, but they basically told Diana, you won't have a purse because we are the Kelly bag. So if you do have anything where you realize that you have like a common name, and I don't know if free love is common, or you'll find that out if you start researching it, but you may get warning letters shot across the bow to you. Did you actually take the time to file the copyright, file the patent, file the trademark, file your name, so that you don't hear from somebody down the road? And like I said, for a small entrepreneur who's only going to sell 8,000 pairs of shoes, a foundation that's going to hire firms like that from Paris and DC could easily put you out of business and soak up all your profits. So you want to take the time to make sure that you sit down, and maybe you say to yourself, well, I'm only going to reserve my name. We had to reserve all 5 things so that everything was protected, because you just don't know who's out there once you're in the internet and in the stream of commerce. So I see you're all learning very quickly to make sure you'll be going around looking at every hamburger you get and every product you get and say, I wonder if they did this, or I wonder if I could do that. Again, it comes down to similarity and your ability to search on the internet with your product in mind, looking at other drawings from other people. For lawyers that work for companies and people that work in companies, this goes on all the time. If your company, out here in McHenry County, there's a company that deals with medical products, or you're dealing with breast pumps, or you're dealing with Snap-on tools or Sage products. There's got to be people on staff who know, what is the competitor doing? What does their product look like? How similar is it to my product? When do I walk across the line of similarity and look like I'm infringing or stealing what they've come up with? My husband's company has a medical device, and it's commonly used, but they think they have something unique about their medical device. But the minute that someone comes out with something unique, you usually get the challengers out there saying, oh, I think you stole that from me, or I think that was my idea, or we had that on our line once, or we tried that prototype. So what you have to do in a corporate sense, as opposed to my entrepreneurial students that are sitting in class, my corporate students that are sitting in class, you got to make sure you save all your drawings. You save all your scrap pieces of paper. I say that to my artists as well, and my singers and my writers. In class, we cover a number of interesting cases. We listen to songs. Coldplay's wonderful song that is my favorite, Viva La Vida, has had Joe Satriani and another group come after them and say that they stole it. And it comes down to, in these cases, not just the juries listening to the music, but it also comes down to, can you show the scraps of paper that show on that particular day you were writing the songs? In that particular case, there was scraps of paper that was in a hotel garbage can that became the key evidence as to whether one of the individuals had stolen the garbage and stolen the song. So if you're doing any doodling here at work and on your major idea and your think process, keep it in a folder, keep it to yourself, don't put it in the garbage here, shred it, because that's where people come up and say, it was my idea, it wasn't yours, it was MCC's idea, you took it. So you want to take that stuff home and keep it, and again, if you're going to show it to anyone, use your NDA, but keep that stuff at home with you, or keep it somewhere locked up so that people can't get their hands on it. We also cover Beyonce has 12 songs and she's been sued for in federal court, which shocks a lot of my students because she's so popular. And when they find out that she and her dad have been sued and lost so many times, it really, I know, changes people's perspective on what kind of artist she really is. Ed Sheeran just had his Photograph song. He settled out of court because literally if you heard his song and the person who claimed that he stole it from him, they were almost identical. And that really disappointed me because I really like his music right now. We cover what can happen to a family if you're not careful when someone comes to you to buy your idea. Winnie the Pooh came from a family in England that had a soldier that was gone, and they really lost out, the Schlesinger family did, to a group that bought it from them and then went on and sold Winnie the Pooh to Disney. And Disney, after all these years, has finally worked that out so that you're going to see the rest of the Winnie the Pooh movies, but it was held up in IP litigation so that you didn't see Christopher Robin, you didn't see Eeyore's stories, because this family in England was saying we didn't get paid for these little drawings that we had. Every family has their story and everybody has their drawings. And so those two, if someone says to you, oh, I'd like to, you did that nice drawing of my dog, can I have that? You need to think about those things before that dog turns into Winnie the Pooh or a famous cat like Garfield. And I will close with this, and I hope I've sparked your creativity today. The Barbie and Bratz case is another legendary case that we cover here at MCC. It went on for over a decade. There were hundreds of millions of dollars of fees paid on both sides. And it's unfortunate because there was an employee sitting around and he kind of drew an angry doll. He didn't think Barbie should look so pretty and smiley all the time. And he didn't think it belonged to the company. And the real issues came down to, did he draw it at night when he was at home? Was the employment agreement and was the manual and were the policies at Mattel that tight that MGA had no rights to have him take those drawings with him? And were the dolls really that similar? I mean, the Bratz dolls had a kind of an aggressive, nasty look to them, and their facial expressions and their eyes and mouth shapes, but as I tell my students, the unfortunate part about that case that went on for over a decade is that both the principals suffered severe health implications after the very stressful depositions and trials they went through for over a decade, and both ended up passing away. And you don't want to, you lose your witnesses too if it's that stressful for your family and your employee if they're trying to save something like the Schlesinger family was trying to save Winnie the Pooh, or this man named Carter was saying that the Bratz idea belonged to him and therefore he was able to give it to his new company. If you ever are in a situation where you're here at MCC or you're here at another company and someone says, can I have your idea? That's the time. Hopefully you've taken my free advice today and you've walked through all these steps and you've secured your idea. But if you're not, that's the time to contact an attorney before you end up signing away a royalty to something that ends up providing billions to a company like Disney. And that's why it's really important to understand IP rights in the workplace, in academia, in our homes, while you're making your recipes tonight. It's a really key concept. And I'm going to open this up for questions. And